Dennis O'Rourke.
Thank you, Mr Speaker. This bill will enact all but one of the recommendations of the Law Commission's 2013 Evidence Act review, and I'd like to begin by thanking the Commission for its work and congratulating the Government for implementing those recommendations. I want to briefly review some of the changes. They're all fairly technical and minor in nature, but still important. And one of them is that the bill alters the law relating to hearsay in criminal proceedings. As we know, at common law, hearsay evidence is generally not admissible, but the Principal Act made hearsay evidence admissible in some cases. It preserved the common law rules relating to statements of co-conspirators and persons involved in joint criminal enterprises, and in that context, a hearsay statement made in a business record is admissible because they are regarded, of course, as being reliable, but only if the person who supplied the information is unavailable or can't reasonably be expected to recollect the matters in question, or if the judge considers that there would be too much expense or delay in bringing such a person forward to give evidence themselves. In this bill, Clause 7 amends that Act by redefining the term business record, and it really did need some definition, and also to exclude police records of statements or of interviews with the victim or an eyewitness. And in Clause 9, the bill adds a new Section 22A, which says that a hearsay statement is admissible against the defendant if there is reasonable evidence of a conspiracy or joint enterprise, reasonable evidence that the defendant was a member of the conspiracy or joint enterprise, and the statement was made in furtherance of that conspiracy or joint enterprise. Those changes are all needed and are appropriate. Mr Speaker, the bill also alters the law relating to improperly obtained evidence in criminal proceedings. And as we know, there's a long-standing principle that such evidence would be inadmissible, but Sections 31 and 2 of the Principal Act provide that evidence may, if evidence may have been improperly obtained, the judge must consider it on the balance of probabilities and decide whether or not the exclusion of the evidence is proportionate to the impropriety. This is done by means of a balancing process that gives appropriate weight to the impropriety, but also takes proper account of the need for an effective and credible system of justice. Now, Clause 11 simply removes the words "but also" and substitutes the word "and", so that it makes it clear that both the impropriety and, in addition, the need for an effective and credible system of justice are considered together. It's just a matter of clarity, but it's an important matter of clarity. There are other amendments, Mr Speaker, in the bill relating to admissibility of previous statements and documents used to refresh memory. Section 35(1) of the Principal Act says that a previous statement of a witness is not admissible unless it is necessary to respond to a challenge to the witness's veracity or accuracy, and the statement provides the court with information that the witness is unable to recall. In this bill, Clause 12 amends these exceptions to necessity to respond to a challenge to the witness's testimony based on a previous inconsistent statement or on a claim of invention by the witness, or the statement simply forms part of an integral part of an event before the court, such as in the example is given of a 111 call. And the other possibility is the statement simply consists only of a complaint made. Those are all, Mr Speaker, sensible changes to clarify the operation of those rules. The veracity rules are amended by clauses 13 and 14 of the bill. Section 37 of the Principal Act provided that a party may not offer evidence about a person's veracity unless the evidence is substantially helpful. And in deciding that, the judge had to consider the fact that the person might have been convicted of an offence showing a propensity for dishonesty, were the words used. The bill removes the word dishonesty in favour of veracity, which means simply truthfulness specifically and not dishonesty generally. So that's a small but important improvement. Concerning the previous sexual experience of a complainant in sexual cases, section 44(1) of the Principal Act provides that no evidence can be given relating to the sexual experience of the complainant with any other person than the complainant, except with the permission of the judge. In the bill, clause 16 would add that in addition no such evidence can be used unless new requirements are met for a written notice to be given stating the name of the person to give the evidence and the subject matter of it, so that everyone will be properly informed beforehand. But the judge may dispense with that notice if any party is substantially prejudiced or if the notice was not reasonably practical to be served and it's in the interest of justice to do so. Mr. Speaker, those changes appropriately clarify the parameters of the judge's discretion, which were not there previously in the legislation. Another change relates to privilege for plea discussions. In section 57 of the Principal Act, it is provided that privilege for negotiations in civil proceedings are acceptable, but in this bill, new subsection 2A extends that privilege to criminal proceedings. But under section 2B, the court may order disclosure where it is necessary for the subsequent prosecution for perjury, subsequent prosecution for perjury, or to clarify the terms of any agreement reached during those negotiations, or if it would be contrary to justice not to do so. More quite sensible, minor but quite sensible changes. Evidential rules on video recorded evidence are amended by clause 30 of the bill, so that a video record must first be offered for viewing by all parties or their lawyers. However, a party is not entitled to be given a copy of a video of any child complainant or of any witness in a sexual case or a violence case. However, a judge may still order that such videos to be given to a lawyer representing the party before it is offered in evidence, if it's in the interest of justice and considering the nature of the evidence. Mr. Speaker, finally, clause 32 deals with alternative ways of giving evidence by a child, and that's of course been a matter for some concern for quite a while. And I remember in Christchurch the Alice case raised a whole range of very difficult issues in relation to those considerations. So this clause says that a child witness is entitled to give evidence in criminal cases by any appropriate means, so long as the judge, the jury, the defendant and the lawyers concerned can see and hear the witness giving that evidence. And this bill says that a child witness who has indicated that they are willing to give evidence in the ordinary way may be permitted to do so if the judge makes that the decision. And in doing so, the judge must be satisfied that the witness fully appreciates the likely effect on him or her of doing that, and for that purpose can call for a report on the likely effects on the witness. I think that's quite a valuable provision. It clarifies the circumstances under which a child witness can give evidence and takes appropriate action to protect the child. So I'm glad to see that there. And overall, Mr. Speaker, all of these new amendments are deserving of support to the Select Committee, and for that reason, New Zealand First will vote for the bill to do so.